stop it, or I can edit
Yeah,
it
sure.
later.
Yeah. Oh, wonderful. Okay.
All right. So
Wonderful.
welcome, Professor Catherine Bond, as Associate Professor at the University of New South Wales Faculty of Law. This is part of our periodic webinar series at the New York State Technology Commercialization Law Program and Sipley YouTube channel. And I'm Professor Ghosh, and I will be listening and learning quite a bit from Professor Bond's work. She's presenting a joint chapter with Professor Jessica Lay at Victoria University in Wellington. And their chapter is going to appear in this book, Forgotten Intellectual Property Lore, which will, has a Amazon page as of today, I think.
Oh,
So it's going to come.
wonderful.
It's coming out
Pre-order now.
October 2020. So in a
Exciting.
few months. Wow, and it's supposed to be almost 400 pages, which I was quite pleased with.
Wonderful.
So look for that. And Professor Bond's chapter is the last one, but we won't tell the other contributors. I think one of my favorites. I mean, the last section about IP during wartime, your chapter with Jessica, and then Arpan Banerjee and Dana Belderman's chapters, I think, are very interesting and a very rich chapter. So please look forward to this. And also, to share the plugging, I also want to point out that Professor Bond is the author of Law and War, which I tried to order before our meeting today, but took a while. But I did download it on my Kindle, so
Wonderful.
I didn't have to worry about Amazon's delays and so forth.
Yeah.
And I haven't read it yet. I've skimmed it. I looked specifically at chapter 8, which I think has some overlap with what we're going to talk about. It deals with aspirin. I guess it deals with trademark law during the war period in Australia, during the Great War, World War I. Okay, well, thank you so much, Professor Bond, for joining us.
Thank you.
And I know you have a PowerPoint to share, so I'll leave it to you. And we have about an hour. We don't have to take the full time, but I mean, I'd like to have you share your work with our listeners, and then hopefully we can have a little discussion as well.
Wonderful. Thank you so much. So I thought I'd start off by, talking a little bit about how I kind of ended up working in this area. So I've been looking at the relationship between intellectual property and war for about 8 years now. And I started after I saw 2 presentations at the ISHTIP conference that was at the London School of Economics in London in June or July 2012. And there were 2 papers there. One was a PhD student who was talking about whether Jewish intellectual property compulsorily acquired in Germany was treated differently to other forms of property. And then there was also a paper by Tina Piper as well that's subsequently been published in Governing Knowledge Commons about military inventions and the commons in Canada. And during my PhD thesis, which I did on a history of Australian copyright law in the public domain, I'd encountered archival material around intellectual property and war, specifically looking at how we might extend copyright to, for example, accommodate wartime circumstances, because obviously individual and business what people are focusing on during war shifts, and for individuals and businesses, they are often not focused on intellectual property. But in contrast, governments actually have been. And from that kind of initial, that initial exposure, I started to investigate more of the relationship between intellectual property and law in Australia. So how law and war were used to create different frameworks to enable the use of intellectual property that was, owned by enemies or individuals who were now considered enemies from countries at war with His Majesty the King, and how law, how IP was essentially used as a weapon of war. So how we could harness overseas inventions, for example, for our own individual war efforts, and how we might maintain secrecy around inventions that were applied for patents, but we didn't want them falling into the hands of the enemy. We wanted to keep that secrecy, in contrast to how patent disclosure usually works. So the position in Australia and New Zealand followed the position in Britain. So in the UK, as part of their kind of first wave of wartime legislation, they passed a law that permitted for the avoidance or suspension of patents, designs and trademarks, those registered forms of intellectual property. And then New Zealand and Australia followed quickly. And this was the case with the early wartime regimes. So it was the case that Britain would create legislation and then it would funnel through to the countries within His Majesty's Empire, within the British Empire, and we would closely follow that legislation. And that was the position at the start, at least. And I'll just note that the position in other countries, though, was quite different. So the United States, for example, I spent a bit of time at NARA out in Maryland, the National Archives and Research Center out there, just about 30 minutes outside Washington DC, and the United States had a very different system. So when they joined the war in 1917, they created an enemy property custodian, and that custodian was essentially responsible for managing and dealing with all forms of enemy property, including intellectual property, and that was actually sold off. So licenses or IP generally, patents were actually sold off to companies within the United States. And Petra Moser and Alessandra Vuena have done some fantastic empirical work around how that benefited United States industry during that period. So within Australia and New Zealand, once we received that British law, we enacted it, or we put it into force in our own countries. And I'll touch a bit on New Zealand first, because then I'll touch on the Australian position. And one of the themes that I think really comes through is actually how Australia, and that's actually what I talk about in the book that you mentioned, Shuba, in this little Law and War book that I've published. One of the themes that comes through about the Australian experience is that we looked at the British position to begin with. We were on board with that, and then we just did our own thing. And the sheer number of laws and regulations that were passed in Australia during the First World War really surpassed those that were created in other jurisdictions. Our Attorney General's Department kept itself busy in all manner of ways, both for IP and in other areas. So in relation to the New Zealand legislation, so what the legislation actually did was it amended the current acts, or the current act in force, the Patents, Designs and Trademark Act that had been introduced in, I'll just check my dates here, in 1911. Now that permitted Crown use of, that act itself as passed, permitted Crown use of different forms of intellectual property, including patents. So the government could enter into an agreement with a patentee to permit them on favourable terms to use a patent. But as in Britain, what the amendment in 1914 did was it allowed the government to, or the Governor-General to create regulations around the avoidance or suspension of enemy-owned intellectual property. Those regulations were created, but those regulations were created, and what the position was that you could make an application and I'll just bring up these PowerPoints now.
Clarifying questions about background history. So at this point, were Australia and New Zealand, they were sovereign nations, or they were no
Yes.
longer crown colonies, right? So,
No. So New Zealand had been from during the. It's interesting, actually. Yeah, both were independent states. Australia had been since we federated in 1901. We became a federation, and actually there was a lot of discussion about whether New Zealand was going to be part of Australia for the purposes of federation. Even Western Australia, at one point, one of the states of Australia, it wasn't sure if they were going to take part too. But no, at this point, they were independent countries, each with legislatures responsible for making laws within that country. New Zealand, as is the case today, is similar to Britain, where it doesn't have any states. It just has that one major government.
right.
In Australia, by contrast, we have states. But then sitting over the top of those states, we have the federal government, our federal parliament as well. And so in Australia, up until federation, each colony, as it was called then, had its own intellectual property regimes in practice. So from about the 1860s onwards, the Australian colonies started to pass copyright laws, patent laws, etc. Then at federation, this became an area of federal power. Patents, copyright, designs, trademarks, all of those are included in our federal constitution as an area for federal regulation. So in New Zealand, they passed the Patent Designs and Trademarks Amendment Act 1914, and then they subsequently created regulations pursuant to that act, and that essentially provided that an avoidance or suspension could be granted in favour of an individual or company who made an application. And in order for that to be granted, it had to be shown that first the applicant intended to work the invention in New Zealand and that it was in the general interests of the community. But as it turned out, there were about 12,000 patents in force in New Zealand at this time. And of these patents, I'm just going to pull up some figures here. So from documents we obtained from the National Archives. So I'll talk a little bit in a minute about our methodology for the paper. And I've got some great photos of how we went about this too. There's a lot of dust involved. So from the documents that we obtained from the National Archives of New Zealand, 72 enemy-owned patents were identified in existence in New Zealand at the start of the First World War. And so this was 72 out of a total of about 12,661 patents that had been sealed in New Zealand at this time. So it's a very small percentage. No patent. So nobody ever applied for the avoidance or suspension of a patent in New Zealand under this regime. The government disseminated this list of 72 patents to various departments, said, okay, do any of you want to use these? And the answer was a resounding no. It wasn't felt that any of these patents had much of an impact, had much of an impact in the jurisdiction.
When you say enemy-owned patents, just to clarify, because that has a lot of meaning, especially in comparison to what was happening, at least in the U.S. during World War II. These would be patents owned by German nationals, or it's a really good point, because I often use that kind of term, enemy-owned, or in the book I talk about enemy aliens a lot, but it is worth defining specifically. So any individual or company. Resident, a citizen of, incorporated in Germany, the Austro-Hungarian Empire, or Turkey. So sorry, go ahead. No, I'm sorry, I didn't mean to interrupt. But if you had German populations in Australia or New Zealand, they weren't affected. I mean, they weren't labeled enemy.
Yeah, that's
compared to the U.S. situation where
actually
Japanese,
they were.
Yeah, okay.
Yeah, yeah. It really it was in. So we had a very in Australia. I'm not sure what the position was in New Zealand, but in Australia we did have quite a large German population.
Mm-hmm.
Either those who had been born in Germany, migrated to Australia, and become British citizens. Or become what was known then as naturalised British subjects. Or we had a lot of individuals who were still German citizens, but had lived in Australia for long periods of time. And as the war progressed, it became worse and worse for enemy born citizens during this period. I'll talk a little bit later actually about the Australian metal industry and patents, and it was the Australian metal industry was controlled a lot by German companies. And one of the examples, one of the men that I talk about in my book, which I'll just bring up now, one of the men that I talk about in my book was a German-born man who'd lived in Australia for more than 2 decades. He was actually interned, and as a means of, he was the managing director of a metal company, and he was actually interned as a way to kind of help dismantle this German control over the Australian metal industry. So it was a very bad period. Yeah, it's and this kind of, my work in IP and war actually led me into looking at other experiences more generally. In the book, as you mentioned, I do talk about aspirin, which is such an interesting story. But the IP elements actually led me in to look at the more general history. So I'll continue then to the Australian position. And I want to start by talking about this man, William Morris Hughes, who was the Attorney General following a federal election in Australia in September 1914. And he was the Attorney General until 1921, and then he was the Prime Minister of Australia from 1915 to 1921. And he was, as Attorney General and then as Prime Minister, he was responsible for using law to enable Australia's war effort. And he didn't hold back in doing this. As I mentioned previously, although Australia initially followed the British position, when after about 1914, moving into 1915, particularly after the Gallipoli campaign, which some viewers may be familiar with, the disastrous British Gallipoli campaign in Turkey that resulted in thousands of deaths of soldiers and was ultimately a failure. After the Gallipoli campaign, and law started to be increasingly used, reactive laws were increasingly put in place in Australia, drafted by Hughes first as Attorney General and then still in that role when he became Prime Minister as well. And he was a very divisive figure. So I have here just an example. I'll stop sharing that photo for a minute. So this was a little book produced, the Billy Book, which really encompasses how, so this is from 1919. And it was by a cartoonist, David Lowe, and it really highlights how divisive a figure he was. He was re-elected during the course of the war. It really was seen that he was the best person to lead Australia during the war. But he was a short man. He was called the Little Digger, and he was as much vilified as he was loved. So he really controlled the strings of Australian law, including regulation of IP during this period.
What party was he? I mean, how did the...
Yep. Okay.
Sorry.
That is a really good question, because so he was originally a member of the Labor Party. which in terms of Australian American politics, the Labor politics is more aligned with perhaps Democrat
Yeah,
politics,
kind of like
and
Labour in
Liberal,
UK now,
yeah,
or then.
yeah,
Yeah.
and Liberal politics more, or our major party now, Liberal National Party, more aligned with perhaps Republican views. And however, during the course of the war, he led the Labor Party. During the course of the war, though, we had a campaign around conscription
Mm.
that received a no vote. So there was a big plebiscite around conscription that received a no vote. The Labor Party was so dissatisfied with Hughes and his handling of the whole situation that they kicked him out, and he created a new party, the ultimately called the Nationalist Party.
Oh, wow.
Yeah, so there was this. So this is just this amazing period of Australian history where there is simply so much going on, both politically, legally, economically, socially, and IP is interwoven with each of these elements. How IP is ultimately used for the benefit of the community, or in the national interest to build up our country, build up Australia during this period.
Mm.
So in Australia, I'll just go back to sharing my PowerPoints again. So as in the UK or Britain, as in New Zealand, we created an act to extend the powers of the Governor-General to permit the avoidance or suspension of any patent or design, trademark. And just to drop in there, those terms avoidance or suspension are really kind of funny terms. Avoid was generally determined to mean that a whole class of people, if a patent was avoided, then a whole class of people was supposed to be able to use it.
Mm-hmm.
The suspension was directed at one person, so an individually. The trouble was how this actually played in practice. It was realised that, well, if you avoid or suspend something, probably anyone is going to be able to use it. So they actually had to make a number of amendments to the law to permit or to create a situation where if a patent was suspended, it became an offence to use that patent, and with quite a hefty fine of about £500, which was about $50,000. So very serious penalties.
Mm.
So the Act was created, and then we set up some temporary regulations that were enforced for the course of the war. And these mirrored the ones that had been introduced in New Zealand as well. So a license a patent would be suspended in favour of an individual or business applicant if the patentee was an enemy, or they were a member of a state, a subject of a state at war with the king. The person applying intended to manufacture or cause to be manufactured the patented article. So it wasn't the case that you could import in the patented article. You had to be able to make it within the jurisdiction. You had to be able to show you were going to be able to make it in Australia. Mm-hmm. And that it was in the general interests of the community or a section of the community that such article should be manufactured or such a process carried out. And so how we went about this project, we went about it in a number of different ways. And so this kind of explains the methodology behind the project. And so the place where we started, so I had done some preliminary work around Australia from about 2013 onwards. And then we supplemented that with materials from the National Archives in Australia and New Zealand, and materials from the Official Journal of Patents in New Zealand as well. So these are images from the Australian Official Journal of Patents. These are from 1915. And in the page where you can see the tables, the patents, there would be applications made to use these inventions, or an individual applicant would make an application to use a patented invention or for it to be suspended in their favour. That would then be recorded in the Official Journal of Patents. The official journal of patents would give information around, for example, who the owner of the patent was, what the patent itself was, the number. They might provide the title of the patent, and then they would provide information around when there would be a hearing and a decision made on if the suspension would be granted. So in the tables, we have applications to avoid or suspend patents or licenses. So 2 tables there listing the patent number. And as there were both Commonwealth and state patents at this time, individual applicants would make applications or could make applications in relation to both state patents and Commonwealth patents under this scheme. So for example, one of the major areas where a patent was, where applications were made was in relation to a process for the production of thermite. So there were a number of patents, both at the state and federal levels, owned by a German company, and the inventors of that were the Goldschmidts. And so you would apply, when applications were made there, they would apply for the use of the Commonwealth and state patents. So there would be a hearing, and then there would be a decision made. What's notable is that there were, as we'll talk about in a minute, there were a number of very successful applications, but no decisions were ever publicly released on whether these applications were successful, like on why these applications were successful. So here we have, so this is from 1915. Just on that right-hand page there, you see that there are notices around the suspension of 2 patents being made by the Commissioner of Patents, and notification of this being published in the Australian Official Journal. And so what we did was, in order to put together a full table of the materials, of the patents that had been suspended in Australia during this time. So I'd previously undertaken some work in this sphere in relation to a 2015 article that was published in the Intellectual Property Quarterly. And for both Australia and New Zealand, we used both information we found in the official journals and supplemented that with information that we found in our national archives. And it was a very messy, you don't think of archival research being kind of dirty and messy, but it did get that way. So this is a picture from the State Library of Victoria when I was going through patent journals in July 2014, and these documents, these journals, some of them you can see there had been sealed, so they hadn't been opened since the 1980s, 1990s, and they're so old, some of them were just dusty and filthy. And then, as I mentioned, we would supplement what we found in the official journals with materials from our national archives, which were generally very easy and accessible, but again, we're looking at really substantial amounts of documents, and often there were no central lists for what we were looking for either. So these are documents around the Patent Inquiry Board, which we also talk about in the chapter in relation to secret patents, so we might get to that a bit later. Yeah. And just the size of these documents, every individual piece of correspondence hung on to, which is fantastic, but Amazing. It means you're going through these 100-year-old documents, and it might just be someone kind of confirming receipt of a letter, or just the amount of information is just incredible.
And so the National Archives information, it looks like it's fairly well digitized. I mean, it looked like from the screenshot it went back to at least to World War I.
Yeah, the National Archives for both New Zealand and Australia, both of them are fantastic, fantastic resources. In Australia, we have a central office in Canberra, but there are state offices too. And because the kind of seat of government for the First World War was in Melbourne, the majority of material was found in Melbourne or Canberra, and for New Zealand, it's found in Wellington. there is capacity for the digitisation of materials by the National Archives itself, which is fantastic. They send you through a PDF. But in the majority of cases for what we were looking for, that digitisation hadn't already occurred.
I see.
So it was either myself, Jessica, or a research assistant going through all these materials and digitising all these materials. Right. I have a Dropbox full of archival photographs, archival documents, that's now very well organised.
And the National Archives would have both state and federal information.
Yes,
for patents and trademarks
yes,
too.
They, and I mean, we're so fortunate because, for example, Amanda Scardamaglia has done a PhD on colonial trademarks accessed through, and published a book on this, accessed through the National Archives. And there's such amazing resources around the history of this country, not only law, but law and trademarks, but what were considered kind of commercial, popular businesses, what people considered to be commercially viable at the time, etc. Right. So we're very fortunate. Yeah.
And when you describe the hearings, those are obviously ex parte, right? I mean, those weren't obviously the enemy combatant didn't have a have a say in this.
Yeah, that's a really good point. So it depended on the circumstances. So in the case of Thermit, and I have just this little booklet here, you kind of, when you work in the archival sphere, you really do kind of get access when you're researching. You just seek to find out everything you can. And this was a little booklet from the kind of the 1910s on Thermit. Just trying to find if I have it. So actually there's 1907 is written here on the document itself, this little pamphlet. And Thermit was used as a way to, it was a process for combining particular metals, and it was commonly used on tramways, railways. So in relation to those kinds of aspects. Sorry, I've just totally gone off topic.
No, this is fascinating. Sorry, no, you were talking about the collection of the hearings and the findings. Yeah. I'm sorry, I didn't mean to.
No. There's just it's fantastic to sit down and talk about IP and war for a bit.
I think it's a topic that needs to be explored, and I've been looking at. I'll talk about some work I'm doing later, but I think it's a really fascinating topic.
Yeah, and particularly the experiences in different countries, the position in Australia being so different to Britain and so different to the US and other jurisdictions as well.
And it sounds I'm sorry, go ahead,
No, go ahead.
I was just about to say, just as a segue for your further comments, it sounds like the uses for either the suspension or the did not have to be for wartime use. I mean, you mentioned the tramways and things. Okay.
Yeah.
Interesting.
So with the hearings themselves, so in some cases, obviously, if the person who has the patent or the company who owns the patent only has a presence in Germany, then they are not going to be, obviously, there's no possibility of them being in Australia to be part of the hearing. But in the case of Thermit, there was an Australian Thermit company who was the owner of the patents in the jurisdiction at the time. And they did make an appearance. But ultimately, a number of the patents related to Thermit were suspended. Interestingly, they weren't actually often suspended in favour, or they weren't suspended in favour of the people who actually applied. They were suspended in favour of the chief of the Commonwealth Railways. So it was identified that actually there was this big public interest in us being able to use these inventions during this time, but the parties who had actually applied were a bit controversial. So Billy Hughes, as I mentioned before, the Attorney General actually intervened and decided to grant these patents or to grant suspensions in favour of this other party. So because this was all happening at a time, as I kind of alluded to before, when there was a lot going on in the Australian metal industry. We were exporting a lot of metals to Germany. Australia was exporting a lot of raw metals to Germany, and our metal industry was really controlled by German companies and businesses during this period. And so there at the time, there were 600, and what's fantastic is that a list was actually put together for the Australian Parliament that identified all of the enemy-owned patents. So German, Austria, Hungary, Turkish residents. A list was actually put together with all the details on who owned these patents at the time.
Wow.
And the vast majority of these were actually granted to metal, in relation to metal-based inventions. So, for example, just one here at the top of this page here. So the patent had been granted to Hans Goldschmidt. It was who was resident in Germany. It was for the title was Improvements in the Process for Joining Pieces of Metal as Rails, Bars, Girders and the like, and completing pieces of metal. Another one granted to Emilio Blecher, Carlos Lopez and Carl Displer, manufacturing of explosives by means of binitro or trinitro derivatives of certain chemicals. So the patents that had been granted or sealed in favour of German-owned businesses or residents, for example, these were heavily focused on metals. So you have this kind of this situation where most of our metals are being exported, and most of the German patents that are in force in Australia are related to metal-based inventions. At the end of 1914, this became, and it's been described by biographers like this area became Billy Hughes's obsession. And I talk about it a little bit more in Law and War. He really wanted to break down the hold of Germany on the Australian metal industry. And so the use of patents here, he used a variety of different laws, as I mentioned before. And when he didn't achieve what he wanted to under a particular law, he would create a new one. So IP, in this sense, the applications that were being made or suspensions granted to government bodies or departments around these metal patents are further evidence of how he sought to dismantle this industry at this time. So patents was one element of a bigger picture of law being used as a weapon of war during this period. This ultimate obsession of the Attorney General at the time, seeking to break down this industry, and patents playing a part of that.
And how did trademarks, I mean, would you want to talk a little bit about that as well? I mean, there's so many things to unpack. I'm a little bit curious about who the petitioners were in the Thermit case. I don't know if you can talk about what were they controversial and why that process is so interesting.
So in respect of Thermit, I'll touch on Thermit, and then I'm happy to touch a little bit on trademarks, because there's the patent area is interesting, because obviously we're talking about being able to use patents in the public interest, but with trademarks, they also import this public interest requirement around public health and building up Australian manufacture. So with Thermit, the initial applicants in the Thermit case, so there were two men who initially applied, Henry Chin and Henry Teasdale Smith. Both of these men were controversial because, so for example, Henry Teasdale Smith, he lodged in late 1914. So he was a New South Wales resident. He lodged an application for the suspension of 8 patents and 3 patent applications relating to Thermit. He was a timber miller and contractor. He often received government contracts for state and federal infrastructure, and there were some questions about the legitimacy of that. And he also was known for exploitation of workers as well. Henry Chin, the other applicant, similarly controversial. He also worked on government infrastructure projects. He was also the individual subject of a royal commission and a select committee inquiry, which is probably about as investigated as you can be by the government. So what happened in this case was neither of those applications were successful. So in the case, Henry Teasdale Smith ultimately retracted his applications. Henry Chin, both of his applications were refused. And then, as I mentioned, the decision was made to grant suspensions to the engineer-in-chief for the Commonwealth Railways over 4 patents relating to Thermit, so that essentially we could take advantage of the current period. There were also licenses granted, a number of additional Thermit licenses granted in New South Wales, so that, you know, we don't need to sugarcoat it. So we could take advantage of being able to use these patented inventions at a period where Australia was building itself, building its infrastructure, and this came at a really convenient time.
Yeah, the war was just a pretext for what could have happened. I guess was there discussion? I mean, it's interesting the way in which war does become a pretext for all sorts of other policies. Was there any discussion about the patent system as a tool of nation building before the war? I mean, there must have been, maybe not this particular mechanism, I guess, but.
Yeah, so one of the things that we explore a little bit in the chapter, and we kind of talked about a lot, is, I mean, the vast majority of patents were being granted to overseas inventors, so to inventors from Germany, the US, and the UK. And so although patents were seen as a benefit to the community, I wouldn't say that it was until I wouldn't say that there was a big connection between patents being seen as a way to build up the nation, or the kind of that connection. Definitely. In Australia, we'd followed the UK's lead. So there was a big problem, perhaps unsurprisingly, given what I've talked about so far, where individual applicants, being as there is today, there's no kind of citizenship or residency requirement to be granted a patent. Right. And with Germany, there was a big problem about German companies and individuals being granted patents, but then not working that invention in the jurisdiction. Right.
Yeah.
So Britain had actually stepped in 1909. We did the same thing and put in place a provision where actually your patent could be revoked if you didn't work it within the jurisdiction under particular circumstances. And so it was being taken seriously that if we are giving you these rights, you need to actually do something for our country. But I think in that wartime period, that's when we really seized upon, particularly led by Hughes, we really seized upon being able to use these creations for national benefit. And that really comes through in trademarks as well. Yeah. So I'm happy to talk a bit about that now.
Yeah, we have about 15 minutes. I thought maybe we could, this is such a rich topic, and the idea is really to get people to be aware of your work and both the book and the book chapter and the other things you're working on. So with that in mind, I think there might be 3 questions that might be of use. One is trademarks. The second is, what happened after the war? Did this become a mechanism then for this type of nation building outside of wartime? And then the third is more where your research is heading. Beyond this. So.
Wonderful, thanks. So with respect to trademarks, again, as with the other legislation, trademarks could be suspended or a license granted to use a trademark. So obviously with all jurisdictions introduced those trading with the enemy provisions, which meant, of course, that if you had trademarked goods, produced by a German or enemy-owned company, how then are you able to deal with those? And originally this wasn't an issue until about 1916, when the government decided it was basically going to blanket ban the use of all German trademarks, all enemy-owned trademarks in Australia. Prior to that, they'd had a system in place like patents, where you could apply to use a trademark, because there was enormous commercial value in being able to use a famous German trademark. And the most famous example of this being aspirin. Bayer, as viewers may know, created the acetyl salicylic acid product in the late 19th century. They got patents for it in a number of jurisdictions, trademarks in more jurisdictions on top of that. So at the outset of war, at the outbreak of war, the aspirin trademark was incredibly valuable. And in Australia, a number of different parties applied to use this aspirin trademark, but the government wasn't giving it away easily. In the same vein as the patent, as that there being some kind of benefit to the community in granting the suspension of that patent, there had to be a benefit to the community in you being granted the aspirin trademark, which meant you had to show that you could produce aspirin. And the first party to be able to do this were two men who I talk about in Law and War, George Nicholas and Harry Wolff Smith. So they were able to show the Commonwealth analyst, and there was this test done. Billy Hughes was in residence there too. They were able to show that they could create pure acetyl salicylic acid that matched the requirements of the German product. And so they were granted a license to use aspirin, which was incredibly beneficial. Because even during the war, and I think this was the case in a number of countries, even though this was a German product, people still wanted that product. They wanted just to be able to go into the shop. They didn't want to have to say, I want some acetyl salicylic acid. They went into the chemist, the pharmacy, I'm after some aspirin, easy. Right. So they were able to fill this gap in the market. And so it's interesting that with patents, we understand that, yes, there is this innovation element as to why patents would be granted or why you might be able to get a permission to use a patent. But here we see that tied to trademarks. We want local innovation in this area. And it's not that we'll suspend a patent in your favour. With aspirin, there was no patent in Australia for the product for acetyl salicylic acid owned by Bayer. But instead, we'll give you this valuable trademark if you can show that you can make this product. And that's what Nicholas and Smith did. That was retracted in about 1917 because the government really clued into the fact, or they realised, wait, we're actually, on the one hand, with the patents, we're getting a big benefit from this local use, but as one parliamentarian said, they were keeping the trademarks alive for Britain. For Germany, for enemy countries during this time. So eventually they repealed those provisions. Aspirin had to be renamed Aspro, which is now a very popular product in and of itself. The Nicholas family, they sold off various elements, but they're still in Melbourne, for example. There's beautiful gardens named after Alfred Nicholas, one of the men involved with the product, and then the Nicholas building in the city. So after the war, this didn't continue. So these regimes didn't continue, which is interesting in contrast to other areas of law that had been created during the First World War and continued after the end of the war and the end of hostilities. So the government actually passed, when it repealed many of the wartime provisions, they created another act that inserted different provisions that they'd found really convenient to use during the war around, for example, sedition, public protest, those types of things. But they didn't continue with this with IP. And I think there are a number of reasons why, the same for New Zealand, why both Australia and New Zealand didn't continue this. I think they recognised that they were essentially a very small player in the area of IP. and that they wanted obviously to encourage people to make their inventions available in Australia, and they didn't want to kind of step on rights. And so they also didn't want to, so on the one hand, they realized they were a small player. On the other hand, they didn't want to jeopardize the IP rights of their own citizens overseas too.
Yeah.
So they didn't continue with these types of regimes until we get to the Second World War, when again these regimes are introduced, and both Australia and New Zealand are much bigger by this time, particularly Australia, and we really get our money's worth for the use of enemy-owned patents during this period. In a 2015 article I mentioned in the Intellectual Property Quarterly, I talk about how, so the big German chemical conglomerate IG Farben industry, which has now, obviously, as we know, collaborated with the Nazi government in Germany during that time. They had built up just an enormous chemical company and other company in other areas during that time, and they had a patent portfolio that was just a mega patent portfolio. And I've got actually this little book from the 1940s which is called Patents for Hitler, and it's actually talks, so it was written at a time when the war was going in Hitler's favor, and then the edition that I have was republished. So it was originally published 1942. The edition that I have is from 1945, and it talks actually about how one of the things that enabled Hitler to be so successful at the start of the war was the fact that he had all these companies in Germany that had these rich patent portfolios. Yeah. And so you asked about kind of future direction. So Jessica and I are moving the project then into the Second World War. And starting to look at that. In our chapter for Forgotten Law, we had in fact intended to talk about the Second World War as well, but we just ran out of space, basically. There was so much to talk about with the First World War, as we've covered today. So we're moving into that space, and we're moving into that space in terms of IP, Australia, New Zealand, their wartime IP experiences. And I'd also like to, with the Law in War book that I just did, look at law more generally and its application in the Second World War. On a kind of longer term plans, one of the things I'd love to do is start looking at Germany and IP in Germany during this period. As I mentioned with the Patents for Hitler book, I think there's an enormous amount to be uncovered there. The National Archives in the UK, for example, has some documents around German IP, and actually individuals who were involved in individuals who were involved in patents actually being held accountable at the end of the war for their actions during the war, and how these patent conglomerates and these licensing chains were actually used to provide the materials for the destruction, for the final solution, for the Holocaust. Yeah. So for me, this is, I feel like I'm at the start of a very significant research journey. I've just only scratched the surface with the First World War, and Jessica and I are looking forward to getting into more work here.
And it's really interesting to see. I don't know if in World War II you see Japan now coming into the picture in Australia with and so that raises a really interesting perspective on sort of Australasia and the whole regional type of IP. So it's fascinating. Yeah. There was a book, I forget the title of it, that came out last year. I think it was from either Harvard or Johns Hopkins I think it had a title, very striking title, like Taking Nazi Technology, and it was largely, you've seen that,
and particularly in the United States, I know that after the war there was a lot of acquisition, perhaps, or encouragement of German scientists who had worked working for Germany during the Second World War, coming to countries, not just America, but around the world as well. Yeah, being offered that opportunity.
Yeah, I think the book, I haven't looked at the book yet in depth. It's not just the human capital, the Werner von Brauns and whatnot, but also the actual patents come into play. And
yeah.
one of the big names in at least the economics of patent law, Fritz Mackleb, was actually the custodian during World War II.
Sure. Yeah. Yep.
So I've actually looked at his archives a little bit. There's just a lot of
Oh,
really interesting issues
yes.
there for
Yeah.
people to explore. So,
Yeah.
and I'm glad you're really you and Jessica and your book Law and War is really leading, in this area. So, thank you for taking the time to
No, thank you.
speak with
It's been
us.
a pleasure. I could speak about this for hours, and there's so much more work to be done, and I'm really looking forward to getting that done.
Yeah, I think we could listen to it for hours. So maybe we can. Unfortunately, Jessica couldn't join us. Maybe I can convince her to do another
Yep.
sequel or
Yep.
something to this.
Yeah. Yeah. Yep.
But
Definitely.
thank you again. I think
Thank you.
if you have any final words or whatnot, we can give you the last say. Or
Oh, I think, we talk about this in a historical context, or we talk about how governments are using law or using patent law in a historical context. But we're seeing that now in relation to talk of the COVID-19 vaccine, patents protecting that. So even though we might talk about it in a historical context, there's still so much relevance today for what is being uncovered and how we might deal with these issues today as well.
Yeah, there's an interesting, maybe overarching theme about IP and national emergencies or in crises. So it's fascinating. So thank you again, and
Thank you for having
look
me.
forward to reading your book on my Kindle or in hard form or something.
Yeah.
So
Yeah.
thank you.